Nice. Kick off. All right, good afternoon, everyone, and welcome to the Canberra Business Chamber's podcast on independent contractors and the right to disconnect. I'm Greg Harford from the Canberra Business Chamber, and I'm joined today by Angela Backhouse from Chamberlain's Law. Today's session comes at an important time as changes to industrial relations laws have brought in new responsibilities and considerations for businesses, particularly around how we support healthy work boundaries through the right to disconnect. And there's some important changes to the definition of independent contractors and how independent contractors are treated relative to employees. So the Closing Loopholes Acts have come into force, and Angela Backhouse is going to talk us through some of these specific elements of those. Angela leads the workplace and commercial law practice at Chamberlain's here in Canberra. She's been there for over 18 years. She specialises in commercial transactions, workplace disputes, litigation, and corporate advisory. So Angela is also a former Canberra Businesswoman of the Year, so it's great to have you here with us today to share some of your expertise with us. So Angela's going to give us a presentation. We will have the opportunity for questions at the end, so please just use the Q&A function at the bottom of your screen if you've got any questions, and we'll get to those as we go. But Angela, I'll hand over to you.
Thank you, Greg. I'll share my screen. Hopefully you can see that. Is that working now?
Yes, that's all good.
Wonderful. So today I am talking about the right to disconnect and independent contractors. As most of you are aware, there have been a lot of changes that have come into place with our Labor government introducing the Closing Loopholes legislation, and that includes the right to disconnect, which I'll touch on initially. This is a requirement that is set out in all modern awards, so applies to all employees under the modern awards, but it is also set out in a Fair Work Act, which means that it also applies more broadly to employees. Basically, the right to disconnect is that employees can refuse to monitor, read, or respond to work-related contact outside of working hours. What does that mean? There's not been much commentary or guidance given to us from the Fair Work Commission about that because there haven't really been any cases come before the Commission or the Ombudsman to provide us with too much guidance. So we are trying to go off what commentary the Parliament gave when enacting this and working through what is in the legislation. Effectively, what it is that it doesn't prevent an employer from reaching out to an employee outside of their standard contracted hours. An employer can still choose to do that for whatever reason, provided it's reasonable. However, what it does do is it gives the employee a right to not respond or engage in that communication. The refusal to respond, however, has to be reasonable. And there are some circumstances where it will be considered reasonable. A good example of that we have seen is, for instance, contacting a staff member outside of their working hours to notify them of a roster change. Or to discuss with them a change to their roster, which may need to be done outside of hours if that roster change is happening before they are coming back into work again. So that's just one of many examples. But when considering whether the refusal of the employee to respond or reply is reasonable, the Fair Work Act sets out a number of different factors. These are just examples of factors. It's not an exclusive definition, but what it includes is what is the reason for the contact that's being made. for instance, is it actually work-related or not work-related? And is it actually urgent or not urgent? Is it something that could have been left until they were back at work? How is the contact being made? And what is the level of disruption? An email, for instance, may be much more less disruptive than repeatedly phoning an employee on the phone. They also consider the extent to which the employee is compensated. So this is quite relevant when it comes to particular staff members that you may have that it may be envisaged when they commence their role that there may be some requirement for them to have contact with the employer out of hours. That might be someone who, say, is in a management position, who perhaps is a manager at a company that does operate out of hours. And it may be envisaged as part of their role that they may be required to be contacted by the employer from time to time to deal with aspects of their role, even though they are not working at that time. And usually it would be expected that that employee is reasonably compensated for that. And our recommendation is that that should then be set out in the employment contract to make it very clear that because they are being properly compensated, that there is an expectation that they will be doing these things, and perhaps even setting out what that expectation is. Whether it's a matter of the employee agreeing that they can still be contacted out of hours provided that it's only by email or something like that. That is all things that should be discussed as part of the employee starting their role. There's also, as I said, the nature of the employee's role and their level of responsibilities, which normally goes hand in hand with the level of compensation that they're receiving. But yeah, if they are at a more senior management position, then it may be more reasonable that they can be expected to respond to communication outside of hours rather than someone who is on standard minimum wage and doesn't have any level of responsibilities outside of their working hours. The one that I find difficult is that the employer is also supposed to take into account the employee's personal circumstances. So the employee may say, look, I'm not able to respond because I'm caring for a small child or an elderly parent or something like that, and it's therefore not reasonable for me to be able to respond outside of hours. The difficulty I find with that is that for a lot of employers, they will know and understand their employees' personal circumstances. However, when you get to large corporations, that may not be the case. And so it may be very difficult to be able to understand when that criteria might apply. There are some significant penalties if you do breach the right to disconnect. So what can happen is if you've contacted the employee outside of hours, the employee has refused to respond to that for whatever reason, and you've then insisted to them that they must be available to respond to you and reply to your requests or demands during that time. If that's the case, then they can make a complaint to the Fair Work Ombudsman to say that you are breaching the right to disconnect. And if after an investigation it is found that the employer has breached that, there can be civil penalties imposed for individuals who are employers of $18,780, or if the employer is a company, it can be up to $93,900. In addition to that, there can also be an award for damages to the employee for interfering with their right to disconnect. As I said before, this is a protected right under all modern awards. And so breaching the award terms can lead to penalties for non-compliance with the Fair Work Act as well. It is possible for an employee to apply to the Fair Work Commission for a stop order. And that would be in a case where an employer is repeatedly continuing to insist that the employee respond or reply to them out of hours, and they could apply to the Fair Work Commission to get a stop order from the Commission to say that they need to cease doing that. The other thing to always remember, which I think is probably more crucial, is the reputational damage that it can do if you're creating a culture where you have an expectation that the employees are going to be replying to you out of hours, and you haven't discussed that with them and agreed that with them in advance. Then that can create a cultural problem within the organisation, and then flow on from that reputational damage as well, which, as we all know how difficult it is to already get employees, that would also make it more difficult. The question that I was posed for this seminar is, how does the right to disconnect apply to independent contractors? Independent contractors are not employees. They are either one or the other. And under the Fair Work Act, it only applies to employees. So if someone is deemed to be an independent contractor, then they are not bound, they're not entitled to that right to disconnect. However, you could have internal policies, or depending on the terms of your contract with an independent contractor, there could be terms in there that say that the independent contractor will not be contacted or not be expected to respond outside of certain hours. And so that comes more of a contractual obligation rather than an obligation under the Fair Work Act. The key issue, however, that I can see is that we have this ongoing saga of determining who is an independent contractor as opposed to who is an employee. And this is an issue that is far from resolved or clear. And I think probably it's something that still needs quite a lot of discussion, but I don't think we'll ever have a black and white answer for. And I'll talk about that in a moment. So just to be clear, when it comes to the right to disconnect, it's a right to disconnect. It's not an obligation. So if you contact an employee and they are happy and willing to respond to you out of hours, that's perfectly fine. And they can do so with no issue at all. However, it is their right to say, I will not be responding to this out of hours. And I guess this just highlights the importance of having open conversations with your employees to make sure you're both on the same playing field when it comes to these expectations. Because if you do believe that you're going to need to contact them out of hours and have them respond, you should have that conversation and confirm that they will be happy to do that. And if they are very clear that they will not be responding out of hours, then you will know not to expect that from them. So again, whilst it is a right of theirs, you can still email or text them outside of hours. There is not a problem with that. There would be an issue if you were phoning them, and particularly repeatedly. But if you send them a simple email or a text, that's perfectly fine. It's just within their right to not respond to that communication until they are back at work. But also, as I said before, there are factors to consider in terms of whether it's reasonable for them to respond or not. And something like a urgent roster change would likely be considered to be reasonable for them to come back to you and confirm that they've received your message and they understand there's been a change. So, as I said before, we've got this unsettled area of law in terms of who is an independent contractor and who is an employee. And the problem we have with this area of law is it's very much factually based on the circumstances in each case. So there is a whole lot of guidance we can provide people, but at the end of the day, it really does come down to your actual circumstances. So just as a guide, What the courts are usually looking at is the whole relationship between the employer and the contractor or employee. And so they will consider a whole bunch of factors to decide how to categorize them. So if they're an employee, usually the employer is the one who has control over how, when, and where the work is done. So the employee must follow those directions and do as they are told by the employer. An employee is usually paid on a salary or an hourly rate or a wage. There's usually set or rostered hours that are either set permanently or on a rostered basis. The employer will usually withhold tax because they are required to do so under the PAYG system, and will pay superannuation on behalf of the employee. And the employee can delegate work. They can't subcontract that out. The employee is required to do that work. On the other side, an independent contractor, normally you would see a pure independent contractor arrangement would be where the contractor determines how, when, and where the work is done. So they may decide what hours they work and where they do that work, whether it's at the employer's premises or somewhere else. The easiest way to distinguish an independent contractor arrangement is where they are paid per job or project rather than being paid an hourly rate. And they will issue invoices for that work that's completed. Normally the hours are flexible or negotiated and set out in the contract to make it clear. And the contractor will be required to manage their own tax and in some circumstances their own superannuation, but I will touch on that in a moment. And the contractor can delegate. So the contractor should be able to, in the contract, delegate the tasks to other people, obviously within certain parameters if that's required. But that's what a pure independent contractor agreement will look like. We see a lot of blurring between the lines in relation to all of these factors with different arrangements, and that's where it can become a little bit more complex to determine who is a contractor and who is an employee. So lastly, I just wanted to touch on common misconception around payroll tax and superannuation contributions. There was a case in 2023 that basically dealt with operation of medical centres and where doctors are engaged under service agreements. The doctors are paid a percentage of their billings and the business would provide the administrative and support services. It's a very common arrangement for medical centres. The main issue in that case was whether the payments to the doctors were subject to payroll tax under the New South Wales contractor provisions, and the New South Wales Court of Appeal found that the doctors were engaged in what was defined as relevant contracts under the payroll tax legislation, and the payments were for or in relation to the performance of work, and the doctors were not conducting independent businesses. The court emphasised the economic reality. The doctors were integrated into the business and relied upon the whole of the infrastructure of the business in order to operate. This obviously has had a major impact on how medical practices now operate, and what had previously been assumed to be contractor arrangements were now, for the purposes of payroll tax, considered to be employee arrangements. And this was regardless of whether they were working under just an ABN or had a separate company. It's situations like that where the veil of the independent contractor arrangement can be interfered with in certain circumstances. So in that case, they may have still been considered independent contractors from an Employment and Fair Work Act perspective, but under the payroll tax legislation, they were considered to be employees and therefore payroll tax was payable. The other aspect we see quite a lot come up and some confusion is around superannuation. because people usually assume that if you have an independent contractor, they have to pay their own superannuation. However, that is not the case in every situation. The contract, where it is wholly or principally for the labour, and the contractor is being paid for their personal effort, skill, or time, and they're not being paid through a company, trust, or partnership, so just through a standard individual ABN, then the employer is still obligated to pay superannuation, even though they are, for all other purposes under the Fair Work Act, being treated as an independent contractor. So that's something that is also sometimes not fully understood when it comes to determining how to pay superannuation, but can actually catch people out if they have not been paying their independent contractors superannuation. That would mean that the employer is not complying with their superannuation obligations. So in essence, the continued legal risks for employers is you need to look out for sham contracting, even mistakenly misclassifying employees as contractors to avoid obligations under the Fair Work Act. It has been frequently found, many circumstances by the Fair Work Commission where people who were thought to be independent contractors are actually determined to be employees under the Fair Work Act, and that can create a lot of issues for the employer where they've been treating them differently. So it's really important to ensure that your contractual arrangements with the independent contractors are drafted properly and taking into account all of the circumstances of the particular contract arrangement you have with that contractor. But also really important to stay ahead of legal developments, because this area of law is changing all the time. There's always lots of different cases coming out, lots of commentary, lots of changes that we see to different areas like the payroll tax, superannuation, things like that. And so what we might think now as applying to this definition does change over time, and not just through legislative amendments. And questions?
All right, thank you, Angela, for talking us through those issues. I guess I've got a question. I think there's a couple of things coming through which we'll get to, but just to be clear, there's no issue with an employer emailing or sending a text to an employee pretty much at any time of the day or night, so long as there's no penalty if the employee does not respond, or indeed the contractor.
Yes, that's right. As long as you're not actually penalising them in any way for failing to respond.
Yeah.
And giving them the respect that they do have that right to not respond.
Do you think that is a material change in practice for business? I mean, my sense would be that most business people are kind of acting on that basis anyway. Is that right, do you think?
Look, I think for the most part, in most industries, there probably was never that expectation. There's probably certain industries where it was more common than others. And certain employers, I guess, that have probably taken advantage more so of their employees than they should have in the past. So my understanding is that the government wanted to try and provide more protection for those more vulnerable employees, because it is usually in those industries that are more at that lower level, minimum wage level, where those employees may not have a lot of options to move and go elsewhere.
Okay. Just on payroll tax, you touched on the application of payroll tax under New South Wales law and a finding of the New South Wales courts. That's broadly the same here in the ACT as well.
It is. It's just not something that's been tested in the legislation, in the case law as such, but it is considered that these same applications would apply. Yeah.
Okay. So it's a question here. What are the implications of the right to disconnect for contractors under long-term or rolling contractors? Rolling contracts when they're effectively integrated into a team. Is there any difference in the advice you'd provide in that case?
No, I mean the thing with independent contractors is that if they are deemed to be an independent contractor and they're not covered by the Fair Work Act, then you are simply talking about contract law, and it is what is written in that contract that's going to apply. And every contract can be very different.
And there's another question here around digital surveillance or monitoring tools. How should businesses approach digital surveillance or monitoring with contractors, or indeed, I guess, the employees, in light of privacy laws and the right to disconnect?
Look, I think that the obligations are the same whether they are independent contractors or employees. If you're going to be monitoring them in any way, that needs to be made clear in your agreements with them, and the policies and procedures need to give you that right. It's reasonable for an employer to digitally monitor their employees, particularly having access to their emails, their work emails, or being able to see what they're looking at online. It's also reasonable within your business premises to have surveillance cameras and things like that. But it is only reasonable if you have notified them of that and that you do have that right to access that. Without that, it can put you in some muddy waters in terms of what you can actually do with that, and how far you can actually go. So I always say to people, make sure that your policies and procedures are up to date, but also have been inducted with the employees, that you've given them training, that you've got signed policies and procedures back from them so you can confirm they're aware of it.
Okay, thank you. Now, look, our last question, unless there's anything else anyone wants to ask, is what policies or contract clauses can business, I guess coming back to the question of policies, what policies or contract clauses can businesses include to avoid the risk of sham contracting but set clear boundaries around availability?
So when you're talking about whether they're going to be an independent contractor or not, and avoiding a sham contractor arrangement, it's going back to some of those factors that I spoke about in terms of the whole of the relationship. So it's making it clear in the independent contractor agreement who has the control, what are the expectations in terms of hours worked, that kind of thing. Because if the control is shifted too far to the employer, they're going to end up being considered an employee, and it will be looked at as a sham contract. When it comes to the right to disconnect and allowing some sort of flexibility, as I said earlier, I think it's really crucial to have those conversations up front with either the contractor or the employee, and making it clear what the expectations are, and understanding from them what position are they in to be responding out of hours. Because if they're saying to you, even as an independent contractor, I'm not going to be getting back to you out of hours, then that can be made clear and even put into the contractor agreement so that you're not breaching any terms of the agreement, and everyone's on the same playing field.
Okay. All right. Well, look, that seems to be the last of our questions. So, Angela Backhouse from Chamberlains, thank you so much for joining us. You're obviously here with your contact details were on the slide earlier. So, if anyone wants to get in touch with you, they should feel free to do that. Equally, if you've got more questions on this, please do reach out to us here at the Chamber, and there's plenty of information on our website too at canberrabusiness.com. So, thank you very much, Angela, for joining us. Thank you to everyone tuning in today. I hope that's been of use.
Thank you, Greg.
Thank you.